Dear audience, welcome to our workshop series on algorithmic market activity and competition law. As you know, this series is organized by the Center for Intellectual Property and Competition Law at Zurich University, CIPCO, together with the Swiss Competition Commission and ASCOLA, the Academic Society for Competition Law. My co-host today is my esteemed CIPCO colleague, Rolf Weber. Hello, Rolf. And we will be looking into agency practice today regarding algorithms. How do competition and other authorities use algorithmic tools themselves, and how do they assess in their practice algorithms employed by market participants? We are very happy to be able to welcome a formidable lineup of practitioners and agency representatives for this topic. With these very brief words, I would like to immediately start with the session, as we have much more interesting content than we have time. And also, we are very happy that colleagues even from the other side of the Atlantic made it to our workshop today. And this is why I immediately pass the word to two representatives from the US. One is Betty Krier, Chief Economist at the US Department of Transportation at the Office of the Inspector General, and the other is Sandra Talbot, Assistant Director at the US Department of Justice, the Antitrust Division, and they will tell us about the practice in the US agencies on this matter. Sandra and Betty, before you start your presentation, though, we will stop the recording, as not all things you will be sharing with us are supposed to be in the open public afterwards. So, hello, thank you for your presentation, and I now stop the recording. Okay, so with that, we can restart the recording, and I would like to now switch to the Swiss situation. With all due respect, it is not very, very frequent that Switzerland is kind of the spearhead of international competition law enforcement, if I may say so. Sometimes it is, but not, not always. And here we are probably in a situation where Switzerland is really leading the camp regarding, the use of algorithmic and complex software tools to detect anti-competitive coordination. And we will now hear about that from one of the fathers and authors of the relevant content, namely Professor Martin Huber. He's an economics professor at the University of Freiburg in Switzerland. And I would like or love to now hear from you, Martin Huber, about the Swiss experiences in comparison with the US ones. Thank you.
Thank you very much, Professor Picht, for this very nice introduction. But I guess I need to give most of the credit to David Imhoff from the Swiss Competition Agency, who was actually one of the first ones, I think, in Switzerland to work on screens. And I actually only jumped in later for combining it with machine learning. So it's actually standard machine learning tools that I brought in here, but combined with these screens of David Imhoff, it seemed to work out pretty nicely for the things that we want to do, namely screening collusion based on historical data. And I also want to mention that in the audience, there's another co-author of mine, Hannes Wallemann, who is also actively working on these tools. So I'm really happy that he's here as well. And yeah, without further delay, I'd love to go over to my presentation. Let me just ask whether you can see my screen now. Yes, okay.
Yes, very well.
Yeah, we can see it.
Okay, so actually the method I will present here is joint work with David Imhoff, and as I've said before, Hannes Wallemann is also working on these methods here. And I just want to give a very brief introduction in how actually such cartel detection methods can be based on machine learning. And we have heard in Betty's talk that one way is to use clustering, unsupervised machine learning, but actually here we will use so-called supervised machine learning. And actually supervised machine learning means that we have historical data where we know whether a cartel was operating or not, and we use these data to learn the specific features in the distribution of bids or prices of cartels versus competitive tenders or markets, for example. So this is what we want to do, right? We want to look at cartel formation in tenders and markets, and we want to predict them by machine learning algorithms. And an example which we used for training our algorithm is actually bid rigging in the road construction sector. And but there are many other examples where you could use that. For example, you could also use it for markets, for example, regional price cartels of gas stations or other providers of products and services, as long as you have information, historical information on whether in some specific region there was a cartel in place or not. As you might imagine, right, if such a cartel is in place, then the pattern of the prices or bids actually changes, right? So what we would expect, for example, is that we have on average a higher price in tenders where a cartel is operating, because actually the cartel wants to seek an economic rent. Another thing we could observe is that among those bidders who lose the contract, we could have a lower variance, right? So that means a lower difference in the prices, because what they usually do is they have cover bids, so they have higher bids than the designated winner of the contract. But then maybe they just are very similar in terms of the prices they actually have. Whereas in competition, you would see prices that go all over the place, right? So there are different features that change under competition versus collusion. And I think a picture tells us more than 1,000 words. So this is now just a little example of what such a distribution of bids could look like when there is collusion in a specific tender. So we have here 6 different bidders, and what you actually see is that the lowest bidder has a substantially lower price than the remaining bidders. So you see here a pretty large price spread between the lowest and the second lowest bidder, whereas among the remaining bidders, so the designated losers in this tender, there's not much difference anymore, right? And under competition, you could imagine that, well, maybe you don't have exactly this pattern that between the first and the second lowest bid, there's actually a huge gap and then only small gaps anymore. So that means, in general, the distribution of these prices, the bids of these prices look different. And this is really what the algorithm is after. That's what the algorithm tries to learn in a data-driven way. What are these differences? And that's what I just said. So we want to learn these particularities of bid or price patterns under collusion versus competition, such that we can distinguish these 2 scenarios from each other. Whenever we have such a machine learning algorithm, which is actually a sub-family of artificial intelligence, then actually we always want to know how well it works, right? So we always want to measure the accuracy. So it's not only enough to actually come up with an algorithm and to apply it, but we actually want to also check how well does the algorithm do. And this is also something we do in the historical data. So for example, what is the share of correct classifications in terms of how often does the algorithm correctly classify collusion as collusion and competition as competition, for example. And then after we are satisfied with the algorithm, if we say, okay, this algorithm in this data set is doing a good job in our historical data, because it gets, for example, 90% correct. So 9 out of 10 times it correctly classifies a tender to be collusive or competitive when it is in fact the case. Then we can actually finally apply this algorithm to newly observed tenders where we don't know whether actually a cartel is operating or not, but there we really want to screen it. So we want to then ultimately flag those tenders which seem suspicious in order to maybe initiate some further investigation. For example, checking whether always the same companies or networks of companies are present in those tenders that have been flagged as suspicious. So what are the requirements for using this method? So we really do need this information on whether there was a cartel operating or not in our historical data. And because this is ultimately required for learning the differences in these price and bid patterns across competition and collusion. And another important thing I want to point out here is that ideally the historical data should come from a context that is close to that context where we want to apply the method. So we have actually done such checks ourselves. For example, we have trained the algorithm using road construction data, and then we have applied it to some completely different market. For example, insurance companies or regional health insurances. And then actually there, it's probably not a very accurate estimate of whether there's collusion going on or not, because these two markets are probably completely different in terms of their general price distribution, right? So this is also something to bear in mind. It's not that you need to train the algorithm once and then you can apply it to any tender or market you want. It learns context specific, if you want to put it this way. So the two ingredients the algorithm actually relies on are exactly these screens. What are screens? Screens are nothing else than statistics which try to characterize the distribution of bids seen in a specific tender. So such a statistic can, for example, be the variance or the average price in such a tender. And there are many, many more. And this is actually something my co-author David Imhoff has worked a lot on developing these screens. The nice thing about machine learning then is that even without knowing which of these statistics or screens are the relevant ones, the machine learner can learn this in a data-driven way. And I think this is a big advantage to previous screening methods, because then as a human being, you had to go through 30 or 40 different screens, right? And some screens in a specific context are more important than other ones. But now you don't need to do this anymore. This is what actually the algorithm does in a data-driven way. It learns which is the important screen to look at, which is powerful for distinguishing competition from collusion in the given context. So here are some examples for screens. I've already mentioned the variance, but again, I think a picture tells you more than 1,000 words. So one screen that we found to be very important is the so-called coefficient of variation. And this is the standard deviation. The standard deviation is a measure of dispersion. How different are bids on average from each other, divided by the average bids. And what we would suspect is that this coefficient of variation is smaller when there's collusion going on. Why? Because when bids are coordinated, then the dispersion goes down and the average goes up. So this entire thing here becomes smaller. And this is exactly what we see if we take a look at this statistic here for a region in Switzerland, where we know when a cartel was actually operating in the road construction sector. Then we actually see that prior to the start of the cartel period, we have a lot of observations of tenders with a high value of this coefficient of variation, whereas on average it goes down in the cartel period. And then after the cartel has been dissolved by the competition agency, it goes up again. Of course, you see also here sometimes small values also in the competition period. So no screen is perfect, right? It's the combination of different screens that makes the method powerful. Here's another screen which is actually based on the difference between the first lowest and second lowest bid. So this is exactly what you see here. And also here you see actually a completely different pattern in the cartel period. So when the cartel was in place, you rarely saw small differences between the first and the second lowest bid anymore. Whereas in the competitive periods, you also saw small differences there as well. Right? So these are just two examples for screens that are used. And they are then fed into this machine learning algorithm. And I don't want to give you too many technical details, but I try to give you some flavor of what the idea of machine learning actually is. So we have a historical data set, right, where we, for example, have several hundred tenders available. And what we then do with these several hundred tenders is that we randomly split them into 3 different subsets. So we have 3 different subsets of data. And in all of these 3 different subsets of data, we do different tasks. In the first data set, which is called training data, we just run a battery of different statistical models. So what that means is that we try to come up with different associations of how the screens actually are indicative for collusion or competition. So what is the association between these screens and having collusion versus competition? And there are tons of different statistical models you can think of. And in the training data, we just run tons of different statistical models without knowing which of them is the best. In the validation data, we then check which of these models is the best one. So we just compare the prediction of our statistical models to the actual incidence of collusion or competition. So how accurate are all these different statistical models for predicting whether collusion or competition is actually present in this tender? And that means by this comparison in the validation data, we ultimately pick the best model. So finally, we have one model, which can even be a combination of several models. And then we come to the last chunk of our data. And in this last chunk of the data, we just assess how well the best performing model works, because this is then indicative for the performance in future unseen data. That is to say, in future tenders where we don't know whether competition is actually or collusion is present in this tender, and where we actually want to apply the method for screening. There are a lot of different methods you could use in terms of statistical modeling, but again, I will not go into detail. Here you see just a list of different methods that are implemented in our algorithm. But to give you the flavor of what all of these methods try to do is the following. So let's have a little example here with just 2 screens, right? So we have just 2 statistics. And based on these 2 statistics, we want to make an educated guess of whether competition or collusion is going on. So let's say the blue dots are competitive tenders and the orange dots are collusive tenders. What you see here in this pattern of historical data is the following, that whenever you have a low value of screen number 1, so when screen number 1 is close to 0, you have mostly competitive tenders, mostly blue dots, right? So one learning outcome here could be from the machine learning is, okay, if screen number 1 is low, then it's likely competition. Among those with a higher value of screen number 1, you see that if screen number 2 is high as well, then we have mostly competition again, whereas when screen number 2 is low, we have mostly collusion going on. So based on such patterns, this is how the algorithm tries to learn what a good model for predicting collusion or competition is. And it does this in a data-driven way. And whenever you do this, even if you have a very well-performing algorithm, it will never work perfect. So you will actually make some mistakes, but you want to know how big the mistakes are. And ideally, your accuracy is close to 100%. That means in your historical test data, so this is the first data set where we want to assess the accuracy of the best performing algorithm. So ideally, you get actually an accuracy which is close to 100%. So accuracy means out of 100 tenders, how many are correctly predicted. And so here, this is the overall correct prediction rate. And here, actually, you would say, okay, in 89 out of 100 tenders, I get a correct classification as competition, if it is indeed competition, or collusion, as if it is indeed collusion. So this is the overall correct prediction rate, but you could also be, of course, and you should be interested in how well the method also works among the competitive cases only and among the collusive cases only. So here you also get this statistic here separately for those where actually a cartel is operating, and for those where actually in the historical data, no cartel is operating, where there's competition. Why is it important to distinguish these two cases as well? Because from the perspective of a competition agency, you might be reluctant to step into companies if you have a high chance that the prediction about having a cartel is wrong, right? So if the method is not very good in classifying those who are actually competitive, that means it classifies a lot of competitive cases as collusive, right? Then maybe you don't feel comfortable with this as a competition agency. Maybe you want to be rather on the conservative side, right? You rather want to maybe miss some of the collusive cases, but really go into these companies, open an investigation for these companies where you have a really high probability that collusion is going on. So therefore, it's interesting to also check this separately for truly competitive and truly collusive cases. If you are satisfied then with the performance here, then you can say, okay, here I have now a statistical model and I will apply this now to new tenders where I don't know whether collusion or competition is going on, but where I actually want to flag them. And that means that if you apply the algorithm then to these tenders based on this statistical model, it will give you a probability of how large the probability of collusion is. So here we have two examples, and in both of these two tenders, actually, so or let me put it this way, in one tender, the collusion probability is judged to be very low. So the probability of having collusion is just 11%, whereas in the other case, the probability of collusion is judged to be higher than 50%. So it's judged to be 76%. So you never get now a clear number saying this is for sure collusion and this is for sure competition, but you get a probability. And depending on how conservative you are, you could say, okay, I would take a look at companies where or tenders where the collusion probability is, for example, higher than 60%. I would have a closer look and maybe check whether there are specific networks of firms operating in all these tenders and so on and so forth. So this is actually all I wanted to say about the machine learning methods combined with screens. And I just want to show you this in action as well. We have developed a little web application for this tool. Let me just see whether it reconnects. Yeah, now it's operating here. So you see here actually an online application, and I will just upload now a data set. And I just want to briefly show you this data set, what this data set looks like. This is actually a data set from a region in Japan. And the data set looks like this, that here the first column is just an indicator for collusion versus competition. So this is a historical data set. And if in this historical data set, we actually do have collusion, then we have a 1 here. And for all the bidders where this is, for all the, tenders where this is not the case, I think further below, we would have a 0 here. And then the remaining columns here just have the bids of the various companies that bid in such a tender. And this is actually all this algorithm needs to actually make the predictions about pollution and competition. So I just feed this data set now into this application. And here, this is also password secured. And now what you see is, first, nothing happens at all, because now the algorithm is trying to find the best model. Okay. So that can now take some seconds or minutes, but what will actually ultimately happen then is that what will come up here is we will ultimately get a result about how well the method works. And here it is. So here you see in these historical data, I obtain an overall correct prediction rate, an accuracy of roughly 84 or 85%. So in 85 out of 100 tenders, it predicts collusion correctly or competition correctly. Now I have my trained algorithm. And now what I can do in the second step is I can just upload a new data set where I don't know whether competition or collusion is going on. And this new data set only consists of the prices or the bids. So there's the first column is missing because I don't know whether competition or collusion is going on, but I still observe the bids of the different participants in this tender. And now I can just upload this new data set, which I call unseen data here. And after I have uploaded this, I get here for each of these 5 tenders a probability that collusion is going on based on the algorithm that I've described before. What you can also do, by the way, if you want to take a look at specific screens of these different tenders, you can also do this. So I can actually upload the same data set here again. Then you will actually see what this does. Here you get actually all these different statistics which are used by the machine learner are actually then computed here. You can also download this file here again. And actually here you also get a graphical visualization of the different screens. Right, I'm almost at the end of my talk. If you permit me to continue for 2 more minutes, I just want to discuss very briefly extensions. Namely, recently we have started to work with so-called deep learning algorithms as well. These are so-called neural networks. So what's the difference between machine learning and deep learning? In machine learning, you still need to provide these screens or these statistics yourself to the algorithm. Then it actually learns what the best performing algorithm, the most important screens are for the prediction. In deep learning, you don't even need to specify the screens yourself, but actually these kind of algorithms can learn from graphical data, for example, pictures, and come up with their own screens in the process to make the predictions. And so one way you can apply this is the following. You can actually plot firm interactions against each other in terms of bids. So what you see here is a first firm and a second firm. And that means a first firm in all the tenders where this first firm actually bids together with the second firm. What we see in this graph is the bids of these two firms in different tenders. So how do they interact with each other? So the first firm can actually bid low, then we are here close to zero, and the second firm can bid low, or it can happen that the first firm bids low and the second firm bids high, or it can happen that the second firm bids low and the first firm bids high, or it can happen that both firms bid high, okay? And what that means is actually that from these patterns, you could also derive whether collusion or competition is going on. Because what could happen is the following: if both firms have a rather high price in a specific tender, then maybe they want to cover someone else who should win the contract. So that means both companies bidding rather high together can actually be indicative for collusion, because there's a third company in the tender that should win the contract. Or it could happen that the second firm has a high bid to cover the first one, such that the first company actually wins the contract, which has a low bid. Or it could be the other way around. The first company bids high and the second one bids low, such that the second company gets the contract and the first one doesn't. So what you can now do is you can feed in pictures with these interactions of companies into this deep learning algorithm. And you see here that under cartels, actually the pictures look somewhat different, or in generally different than under competition. The thing is, you as researcher don't even need to know what are the things that are different. This is what the algorithm will learn. If there are differences in these pictures here under competition, and these pictures here under collusion, then the algorithm will figure that out itself. You don't even need to develop the screens or the statistics yourself. And this is recently what we started 1 year ago, roughly. And actually, this is what you see here. Probably this picture is not really telling to you, but you see here now there are funny graphs coming up here in the lower right corner of my presentation. And actually, when this green line down here goes up, then actually that means the algorithm is doing a very good job in correctly separating collusion from competition. And so it learns from these pictures over time what collusion and competition looks like. And so this is actually a data set where it's just running from Italy, and there we actually got the correct classification rate of roughly 95%. All right, but I think with this little outlook to what might still come up in future, I think there's a lot of more potential using deep learning methods. I would like to close my talk and would like to thank you for your attention. And I'm, of course, very happy to have further discussion and questions right now.
Thank you so much, Martin Huber. That was most interesting and also relatively understandable, even for me as a legal guy. I'm sure we'll have these discussions and questions. However, I suggest that we go on right away to your UK CMA colleague to hear what he has to say on all of that, and so that we can afterwards, discuss the practices together. And so I would now turn over to Chris Tinnen, who is a lead data scientist at the UK CMA. And Chris, having seen the presentations from Switzerland and the US, is it, is the CMA far ahead, and does it look funny what they do, or are you impressed, or what is your take on these presentations? Where do you stand in the UK?
Oh, right. I mean, first of all, two very interesting presentations that we've just had there. Certainly, I'm personally impressed. I can't speak exactly for what the CMA as a whole would think, but these are certainly issues which the CMA has got a very active interest in, and lots of the sort of discussions about these sort of machine learning techniques and some of the challenges that we heard earlier from our American colleagues definitely resonate with my experience so far at the CMA. So I definitely do think we've got a lot that we can learn from each other. but it does sound very much like there is some very exciting work going on, and our colleagues are very much on the cutting edge of what's going on here. I'm going to share my screen. Give me 1 second. Great. Please tell me, can everybody see this? Great, thank you. I'm going to go into presentation mode. So, okay, fine. So I can't see you at the moment because I'm presenting. So please just sort of intervene, just speak up if anything seems to be going awry. So after sort of 2 very sort of interesting discussions, and we've gone into quite a lot of specifics around sort of procurement and bid rigging, actually, I'm going to take a little bit of a step back and I'm going to present things at a bit of a broader level. So we'll still try to cover some interesting examples of the type of things that practically are going on at the CMA, but we won't go, I think, into the sort of quite the level of detail that we've just seen. And also, I should just throw out there at the top, similar to our US colleagues earlier, that I will talk a lot about things that are in the public domain, but I can't say definitively that everything that I say definitively represents the view of the CMA, but hopefully we'll go through a lot of interesting things that we've put out there publicly, so you've got a very good idea about where we're at. So in this presentation, I will go through sort of 4 main areas. First of all, I'll give you a very brief introduction to myself and to the data unit that we have at the CMA. I will then talk a bit about how we're investigating algorithms and how algorithms form part of the casework that we do at the CMA. I will talk briefly about the DRCF. This may not be familiar to everybody in the audience. The DRCF is a relatively recently assembled cooperation forum between 4 of the largest regulators in the UK. I have been sort of leading a project into the issue of algorithmic processing. So I can give you a little bit of insight into what we're doing there and how I think coordination and collaboration can be quite helpful in this area. And then finally, I will talk at the end about the analytical capability that we've built in-house. So we'll kind of start with the regulation of AI, and then we'll move more on to the use of AI for regulation. So hopefully we'll see it from both sides. So a little bit about myself, so you know where I come from. So I'm a lead data scientist, assistant director of data science at the CMA. I've been there just over 2 years. But prior to that, I was really in the private sector. So I was one of the first data scientists at Spotify, although we called them data analysts back then. And I've got 5 years in financial services, designing and analyzing equity trading algorithms. In fact, my very first job out of university was working at UBS in London, doing that exact same thing. So I feel like I have an appreciation for both the regulatory side, but also the practical side of how companies are putting algorithms into practice, and actually many of the benefits that algorithmic systems can offer. In terms of the CMA, we have a data unit. I'm sure many of you are aware. It's quite reasonably well established by now. It's been around for about 3 years. I think we like to think that we are sort of at the cutting edge of regulatory authorities globally in this area. We've got quite a lot of people. I think we've got about 50 people now. So we have our sort of chief officer is a chap called Stefan Hunt, who some of you may have run across in the past. And underneath him, we've got these sort of 5 different areas. We have our digital forensics tool team. So that's really involved in sort of the actual systems that we use to, things like ingesting documents and helping case teams review and look at documents and meeting certain legal and evidential standards. I'm not going to talk as much about that today, but obviously it's a very interesting realm in which there is a growing element of AI. We have a data engineering team that have built our great data platform that we can use to process huge amounts of data. We have a data science team, of which I am a member. We have our data and technology insight team, which do a lot of supporting our case teams within the CMA. They get very much embedded onto the things that we're working on. And then we have our behavioral hub, who, similar to our data and technology insight hub, our behavioral team work with case teams on things to do with things like dark patterns, online choice architecture, those sorts of things. They work on behavioral issues like subscription traps and misleading design practices online. So with that very brief overview, I will give you a review of the investigatory work that we have done that has involved algorithms. And just to set some context for this, probably the main point of reference.
Chris, sorry, I don't think your slides are moving.
Oh, okay.
No, yeah, now it's fine. Now we're on the context slide.
We are here, context?
Yep.
Great, thank you. Yeah, do let me know if that happens again.
Okay.
Thank you for that. So yeah, the main one of the main points of reference here is the algorithms paper that we published at the CMA January 2021. Very well received paper on how algorithms can reduce competition and harm consumers. I hope people have seen it, but if they haven't, it's quite a good read. And we do cover it from quite a few different angles, some of which I will go into here. Another bit of context is that the CMA, unlike our US colleagues, the CMA, well, not unlike our US colleagues, but the CMA is both a competition and a consumer protection body. So we have different regimes. We have a markets regime, a mergers regime, an antitrust regime, and a consumer regime. And obviously those different investigations and their different cases come with different powers and different ability to get information and different legal and evidential standards as well. So we always are, when we're thinking about how we investigate algorithms and think about algorithms, we're always cognizant of the fact that depending on the nature of the case, we have different powers that we can leverage against the parties that we are either investigating or working alongside. And finally, another thing that informs a lot of this debate is the digital markets unit, which is something that is being set up through the government to investigate and oversee large tech companies. And this is sort of in its formation stage at the moment, but certainly that team and that group will be very interested in the issues around AI and algorithms. Okay, next slide. So the algorithms paper has been very well received. We have seen, one thing that we've seen from this is that, as you can see from some of the press here that we got about it, we've got BBC News in the bottom right, who are covering the algorithms paper.
Slide 6. Chris.
Oh my God, fine. No. Maybe I'll just do it here. Is this working?
Yep, now we see some.
Okay, I'll just do it here. So yeah, what was interesting is that when we put the algorithms paper out, we got very good coverage, but we had different outlets cover it from sort of slightly different angles. And so you can see BBC News in the bottom right have covered it from a perspective of hidden price rises. The one in the top left is from the Mail Online, sort of more sort of social fears. Top right, a piece relatively recently that did reference our paper, which was about the role of sort of chatbots. And so I think it illustrated that as an investigatory body like the CMA, which covers, you know, a significant number of industries, algorithms are quite ubiquitous across all industry. And this means that there is a huge, they are becoming increasingly part of all our activity at the CMA. And so we're very conscious and working hard to develop our capability in understanding how to analyze and investigate these algorithms, especially when they can crop up in many different contexts. So the algorithms paper itself, I mentioned that it touched on both consumer harms and competition harms. Here are the examples of some of the consumer harms that we pull out in the paper. So we've got unfair ranking in design. For example, if you have a booking site for a hotel that is sort of presenting results in a way that is not advantageous to the consumer, but is advantageous to the booking site itself. Perhaps, you know, hypothetically, it may stand to make more commission from certain partners that it works with. But those research results are themselves not in the interest of the consumer. And we have other factors such as sort of personalization, sort of through manipulating user journeys, or discrimination, which along with something that we consider is also something that is covered through the Information Commissioner's Office in the UK. And then we have competition harms. So self-preferencing, algorithmic collusion. We've heard we've heard the ways in which algorithms can be used to detect collusion, but obviously algorithms themselves may be involved in facilitating collusion. And finally, ineffective platform oversight, where we've got ongoing investigatory work into the prevalence of fake reviews on certain online platforms. And to reflect what this looks like in terms of actual things that we have worked on, these are 6 different examples. We have the Facebook Giphy merger, of which sort of the use of data and the way in which data flows and algorithms play a part in competition was an aspect of the decision that went into that merger case. We've got the hotel booking sites that I've mentioned previously. We have an open antitrust investigation into Facebook Marketplace algorithms. We have Google's privacy sandbox and deprecation of third-party cookies. We've got fake reviews that I've just mentioned, and we also have our ongoing mobile ecosystems app study, where we published an interim report just a few months ago, just before Christmas. And part of this is to highlight the fact that these investigations all involve data or algorithms or AI, but they cover the breadth of what the CMA does. So here we have a merger, we have an antitrust case, we have a market study in the bottom left, and we have consumer cases in terms of fake reviews and the hotel booking sites. So we as a team are very much working across the entire organization, and I think that has been working quite well. Finally, I will talk a bit about the DRCF. I'm slightly, I don't want to say hamstrung by what I can say, but we don't have a huge amount of public output, so I have to be somewhat cautious about what I say. The DRCF is the CMA, Ofcom, the ICO, and the Financial Conduct Authority collaborating on a set of different work streams. And it was established, and it's had its first sort of proper year in the 2021-2022 UK financial tax year, which is just about to finish. And these were the 3 priority areas that were in the work plan. The work plan is public, that were in the work plan for the previous year. So this is a group where we're aiming to come together to learn from each other and collectively respond strategically to developments in technology, build common capability and develop joined up regulatory approaches. And one actual quite positive output of this so far is that the CMA and the ICO together were able to launch a joint statement on Google's privacy sandbox, which has had very good positive impact. Myself personally, I'm leading the algorithmic processing work stream of this. These are the 3 key things that we've been looking to do over the past 12 months. So we've been looking to assess our shared objectives and challenges. So this is identifying both mutual areas of interest for regulators, but also where the gaps may lie. We've done a lot of engagement with stakeholders, both within sort of government and regulatory bodies, but also with academics and with industry. And we will be reporting on shared regulatory tools and approaches. Practically, what this actually means is that we are aiming to put out 2 fairly detailed papers as presenting a collective view, one of which will focus on the mutual areas of interest for regulators, or for our 4 regulators, and one of which will focus on the what we consider a relatively nascent field of algorithmic audit and what it takes to audit algorithmic systems, and how or what role regulators potentially might be able to play in that market. And I can't guarantee when they will be coming, but I'm hopeful that they will be published within the next 2 months. So do stay tuned, and hopefully they'll make very interesting reading when they get published. So moving on, I will give you some interesting examples of the analytical capability that we have built here at the CMA. Sometimes we think about regulating AI, and sometimes we use the term AI for regulation. Personally, as I think this is something that was touched on earlier in an earlier presentation, it doesn't always have to be AI for regulation. We're very pragmatic. There's nothing wrong with using a spreadsheet if that is the best tool to get the job done. So we like to think of it not only AI, but sort of how we can use digital capability, statistical methods, modern machine learning methods, all of these different things to help serve the CMA in its day-to-day operations. And that is part of the reason that we've hired a team of data scientists. And forgive the slightly benign slide, but what is a banal slide, apologies. What is a data scientist? What does a data scientist do at the CMA? And you may have seen this Venn diagram before. It's classic. Drew Conway, it's about 10 years old now. What is a data scientist? And we have a bunch of data scientists at the CMA, and we have to think for our team and our data scientists, is our job to be people who, in our day-to-day work, do we regulate AI or do we help build AI for regulation? And there is some overlap in the type of skill set that you might want for that person, but also there's a lot of ways in which those two things differ, right? So if you're building AI tools for regulation, you need to think about, how do I actually deploy these tools? How do I put them in front of people? How do we productionize things? Whereas if you're thinking about regulating AI, it's very helpful to have a legal background, a policy background, and to be, quite comfortable writing and reading sort of very long documents that are necessary as part of the various processes that we go under. So the truth is, at the CMA, we have both. And I like to kind of bring out this quite large sort of data science roadmap of what is data science in sort of the modern day and age, to remind people that it is an incredibly broad field. And actually, we've got people within our team who are extremely good at the data engineering side, which is in the top right. We've got great people in machine learning and statistics, but we've also got a lot of people who are very good at this sort of business acumen, the storytelling elements of it. And one thing that we're constantly developing and working on as a team is how to get that balance right, and how to make sure that we hire the right people who are going to help us deliver the type of impact that we want to have for the organization. So I'm going to quickly go through the next couple. I'm cognizant of time. So this was kind of something I put together once, sort of economists, to kind of illustrate the ways in which the way in which AI can be used for regulation may differ from the way in which traditional economics or econometric methods might be used for regulation. And so for me, I personally feel like the role of data science and the role of machine learning has allowed organizations like the CMA to, if I was to borrow an economics analogy, it's allowed us to scale our capabilities horizontally and vertically. In the sense vertically, in that we can now process and deal with data at a volume that previously would not be possible through, SPSS or Stata or something. We can really deal with billions of rows of data because we're building on cloud technology. And then finally, we can scale horizontally. We can deal with sort of non-traditional forms of data, text data, image recognition data, network analytical methods, the types of things that actually may come into play in things like cartel detection or bid screening. And so this is also to illustrate that we complement our economists and econometrics teams. We don't replace them. We work together and we try to bring our best skills to the table. I will leave you now with 3 concrete examples of things that we have done in the CMA that reflects the way in which we have used our capability in our data science skills in ways that previously wouldn't have been possible had we not built and developed our data unit. The first of which is the CMA's investigation into CMA's market study into digital advertising. So this was a 1-year markets, all our market studies are 1 year, but this was a market study that we did. It wrapped up, I think, early 2020, where we were looking at the role of digital advertising and the market power by the main participants. This graph, one of many in the report, was aiming to look at how much search data, how many searches that were happening on Google were also search events that were happening on Bing, and how many search events happening on Bing were also search events happening on Google. So sort of how much mutual information did these two platforms have on traffic that was on the other platform? And what I would focus on here is less about what the graph is actually telling us, and I want to focus more on how the graph was put together. So the way in which this graph was put together was that we were able to take huge quantities of search data from both Google and from Bing. We're talking, vast volumes of data, sort of billions of rows of data, and ingest that into our data platform. And we were able, and so our search data, I should clarify, was, that we received was sort of completely encrypted, and we didn't actually have access to underlying searches themselves. It was completely encrypted, so we couldn't work out what the search terms were. But through our data platform and through the way in which we interacted with the parties, we were able to get this data in a way that we could put together this graph with billions of rows of data. That was only possible because we were able to handle that degree of data within the platform that we had built and that our data engineering team had built. And if we hadn't had that, we would never have been able to put together this type of analysis. We can't do it because obviously we wouldn't be able to have the data shared between the two parties. We had to act as the sort of secure middleman in that instance. Another example is how we responded to the coronavirus pandemic. So the CMA set up a online web form shortly after the onset of the pandemic to allow people to, members of the public, to file complaints or share information with the CMA about issues that they were seeing. And that could involve price rises, it could involve issues to do with cancellations, people not being able to get refunds for their holidays, or any other issue that they kind of wanted to write to us about. So we received vast volumes of complaints. We received over 100,000 complaints. And through the use of various, because in general, this was quite unstructured data, we were just receiving text in terms of what people were complaining about. We were able to do a whole bunch of different bits of analysis through data pipelines and through the use of natural language processing techniques, classification techniques. We were able to ascertain from the name of the company and the content of the complaint if it was particularly likely to be about a certain sector. So you can imagine that if you've got certain terms such as wedding venue, it's likely to be in the wedding sector. So we were able to build that within our data unit team, but then work alongside our colleagues across the CMA, particularly our consumer teams, to achieve important outcomes that were able to help protect consumers in the UK throughout the pandemic. And finally, I guess somewhat similar in spirit to some of the work we've seen so far on bid rigging. Oh, sorry, not bid rigging, sort of procurement issues. This is an example of something we've done for resale price maintenance cases. So resale price maintenance, where we have a manufacturer of a particular item who then places restrictions on the prices at which retailers are able to sell that item. So we have a blog post where we talk about a tool that we built to allow the case team. The case team at the time was working on a variety of musical instrument cases. This is why we have a Roland G70 keyboard here. We were able to collect data and we were able to present it to the case team in a way in which allowed them to conduct their analysis more efficiently. And interestingly, we're able to, having data from multiple different retailers of items, we're able to apply a variety of different statistical methods. For example, on the right is an example of how we might be able to use network analytics to look at similarities of prices between different retailers and then identify where there might be groups of people who potentially seem to have quite similar pricing to one another. That could inform further investigation. It could, in theory, inform a further action to be taken, such as a warning letter. And so these are capabilities that we have been building, but we've always been building them in collaboration and conjunction with our colleagues who actually work on the cases day to day. And if there's one thing that I will leave you with, a strong belief of mine that I've learned throughout my career, is that the numbers themselves have no way of speaking for themselves. We speak for them. I know Nate Silver can be a bit of a divisive figure at times, but I really like this quote. And for me, it's a constant reminder that we, as data people, imbue meaning to the numbers, and it's important that we work with our colleagues and our domain experts across all our different functions to best understand how we can interpret and present data in a way that is accurate, meaningful, and has impact for them. And certainly, we've been going 3 years, but I'm sure it's just the beginning of a very long journey. And so I very much look forward to seeing how we develop and build on a lot of this framework going forward. And with that, I will wrap up. Sorry if I've gone slightly over time.
Thank you so much, Chris. And you spoke for the numbers most fluently and most convincingly. That was very interesting, seeing that broad range of activities of CMA and yourself in this field. Also, with a quick look at the clock, I would suggest we make something like a 5 minutes break in order for the financial market authorities to get ready for their kickoff, and then hear about the financial market situation, and then do a broader Q&A at the end, so that we make sure we have enough time for discussion at the end. Hope this is fine for you. Looking forward to Alain, to your presentation. Okay, so welcome back. I briefly start the recording just to restop it in a moment again, because we will now hear from Alain Girard. He's a senior manager with the Swiss Financial Markets Authority. I do want to use the recorded bit, though, to thank him very much for being with us and for sharing insights on your practice in this regard with us. And these insights are actually not, meant to be shared with the general public. So this is why I now stop the recording again. Concise last stretch, which really, I think, brought, an additional facet to the table in the sense of that very proactive real-time supervision now being, at least thought of to be implemented in the financial markets. Mani Reinhardt, you have heard now so much about the agencies and what they can do and what they will do and what they want to do, and how, even the more regulatory approaches developing in the competition agency world is now from the financial markets agencies, maybe still too much exposed and too little ex ante. What can be done will be done. We have heard this today already. And how does that feel from somebody, also having to represent companies that have to try to navigate compliantly and safely in that field? What's your take on all of this? Are we headed in the right direction with these new agency approaches and tools?
Yes, thank you. I'm just trying to share my screen. I assume that as I'm one of the last persons to speak, and one of the persons that is not from an authority, my role is a bit here to spoil the harmonic mood that exists so far. I'll try to do that, and add a few points, maybe from a practitioner's point of view who represents clients. I mean, as the other speakers, I have to make clear that I only voice my point of view, so I'm not talking on behalf of any client, so that cannot be ascribed to any third person what I'm saying now. Now I'm having difficulties to change the slides. Maybe I go to presentation mode. Okay. I think just I think a clarification. I think if we talk about algorithmic tools, there are two aspects to it. I mean, one set of tools, they are used to search documents more efficiently. So if you have an investigation and you have terabytes of data, algorithmic tools are today used to search these documents more efficiently. This is not what I am talking about. I'm more talking about algorithmic tools that are used to detect infringements or to explain some aspects of it. And I think I will basically deal with three questions. Are algorithmic tools permissible evidence? What is their evidential value? And are they useful, or when are they useful? Now, to the first question, I think if you go to the law, Article 12 of the Act on Administrative Procedure, basically lists 5 means of evidence which an authority should be using, which are documents, information from parties, testimony, visual inspection, and expert opinions. And if you read the wording of this Article 12, you could get the wrong impression that this is kind of an exclusive list and no other means would be permissible, and that is not the case. So the authority is free to use any evidence it can get. There are some exceptions to it, like wiretapping and using undercover agents, etc., for which there is no legal basis, at least in Switzerland. And that means that algorithmic tools can and should be used to establish the facts of the case. And that then turns to the question, I mean, what is the value of algorithmic tools? And the basic rule in Swiss law is, I mean, the principle of free consideration of evidence. So all evidence is assessed on a case-by-case basis. There's no hierarchy of evidentiary means. And that means that evidence is assessed in the concrete case, and the conclusions are drawn thereof. I mean, my view, and maybe that's because I'm old white male and a bit more conservative, is that still when the question is, was there an agreement, was there a concerted practice among some companies, my thinking is still that, you know, the classic old document is still the best evidence, because if you have electronic communications, then these communications are a direct expression of any meeting of the minds. And I don't think that this is something that algorithmic tools can replace. I mean, in my view, algorithmic tools, at least to the extent they have been used in Switzerland, they rather reflect the effects of an agreement rather than showing its directly showing its existence. And maybe not surprisingly, algorithmic instruments have not played a major or not a primary role in establishing the existence of an agreement. They had rather a supporting role. And maybe if we touch on another point, standard of proof. I mean, generally in investigations, all facts have to be proven fully. There are some exceptions from that standard of proof, but generally the strict proof has to be established. and only in unannounced inspections, so-called dawn rates, probable cause is sufficient. That's quite low threshold. I mean, I'm not saying that's totally easy, but I think that is a threshold which is more easy met, and where typically we have seen that algorithmic evidence has played some role. And maybe if I try to translate that into the case law and the practice, I think there are two examples from bid rigging cases in Switzerland where algorithmic tools played a role. One was the Seegaster case that was mentioned. I mean, the case was not mentioned, but basically it was a case where the Swiss Competition Authority had the assumption, based on the screening test we heard earlier today about, that there was a bid rigging agreement among 6 companies. And maybe if we turn to whether this assumption was correct, I mean, the interesting thing was the Swiss Competition Authority performed this screening test. The screening test showed that there was some likelihood that there was a bid rigging agreement between 6 companies. And based on this result, the Swiss Competition Authority conducted unannounced inspections at these 6 companies. And the investigation that followed to that dawn rate clearly showed that these 6 companies were engaged in bid rigging. But what was also interesting to see was that the screening test did not catch 2 companies that were also involved in this bid rigging agreement, and that only showed up later based on leniency applications and other documentary evidence. So I mean, if we have some conclusion here, basically the screening test would have not been sufficient to fulfill the required standard of proof, but it was sufficient to conduct dawn rates and unannounced inspections, and then to trigger an investigation. And I think the second case is the Graubünden case, where basically it was another bid rigging case where the authority calculated that the bid rigging had led to 8 to 10% higher prices. And this conclusion was inferred from the allegation that the parties had used the so-called mean value method. What does this mean? This meant that each party of the bid rigging calculated its bid independently, and then the parties sat together. They first determined who would win the bid, and then they would set the price of the winning bid. And how did they do this? They did calculate the winning bid as an average bid of all the other offers that each party had basically calculated. And from that mechanism, the authority then calculated that the prices that were, offered as a result of that bid rigging agreement were 8 to 10% higher than they would have been without bid rigging agreement. And I think that conclusion in itself was methodological, was correct. But then, a methodology is only as good as its assumptions. And there, as a practitioner, I think there was some evidence that the mean value method was only partly used. So that would not apply to the whole set of prices. Then also there was some evidence that the parties took into account the value method when they calculated the cover bids, because they calculated their bids a bit lower because they did not want their competitors to have a good margin. And the parties also had, I mean, there was also evidence that the parties also had to take into account offers of outsiders of the agreement. They did not want to undercut their predetermined winning bid. So, I mean, basically what this shows is, yes, you can have a good methodology and statistical methods, but if the underlying assumptions are not correct, then the result out of the calculation will not be correct either. And that leads me to the conclusion. I think algorithmic tools are a good additional tool to establish aspects of competition law infringements. And I think authorities should be encouraged to use that. And they are, I mean, the downside of it is only that I think so far in the cases we have seen, they did only reflect, you know, the effects of an alleged conduct, and not were not basically basic and direct evidence of that conduct itself. And then that, I mean, that raises two questions. One is you have to be very cautious about the assumptions you make when using these algorithmic tools. And if there is direct documentary evidence, I think that is still preferable, as it is often a direct expression of the conduct. So I think it's a good complementary instrument and it should be used, but it has also its limitations. Okay, thank you.
Well, thank you very much, Mani Reinhardt, for the most interesting insights from a practitioner's view, having nevertheless also an academic record from the very early days of your career. I would like to shorten my final comments in the interest of time to a very few remarks. I'm not going to give a full comparison of all presentations that you heard in the course of the afternoon. I think very generally all speakers have acknowledged the need of regulators to invest more efforts into the application of new technologies. In other words, regulators are really faced with the need to use technology to address the challenges of monitoring and enforcing increasingly demanding regulatory requirements in a fast-changing, rapidly growing environment. And this means, as a consequence, algo technologies offer the potential of continuous monitoring capacity, providing close to real-time insights through deep learning and artificial intelligence filters into the functioning of markets. We have heard several times from the US over Switzerland to the final remarks of Mani Reinhardt that algorithmic tools can be used to establish unlawful conduct, but nevertheless, coming partly from financial markets, I would also like to add that private participants also do have economic incentives to minimize rapidly rising compliance costs. If you think, for example, of anti-money laundering laws in this field, and this is also a reference to Alain Shearer, we do even have private interests in having algo tools. There were obviously a couple of differences in the four countries. On the one hand, the economic models are not identical. We heard from the US that due to the lack of historical costs, new econometric models are developed. Secondly, there are, of course, also different scopes of application, whereas in competition law, the main focus of this afternoon, algo means are mainly used in the procurement field or in connection with horizontal competitive restraints in financial markets approach of the regulatory authorities covers generally the banking sector and even does have systematic functions or systemic functions which are to be upheld. Nevertheless, as Alagir has shown, I do think that the different sectors can learn from each other, and I very much liked the approach of Chris arguing that an interdisciplinary approach should in fact be chosen. This leads me to three final questions which eventually could be taken up during the forthcoming discussion. First point, formidable implementation challenges remain with the application of algo tools, hampering wider adoption and acceptance of these algo tools would obviously lead to the questions, are technologies always properly functioning? What about technological problems? Do we have a second review of the results shown through algo techniques? A second question, as algo tools take on a greater role in prudential supervision now, mainly in financial markets, but partly also in competition markets, supervisory judgment may diminish. Is this desirable? What about free consideration of evidence in proceedings? Do we have to forget about the notion of free consideration? I guess this also relates to a remark of Mani Reinert. And thirdly, experience with virtual inspections and wider use of algo tech tools have sparked a broader debate about the function of supervision. Do we have to generally define what supervision should mean? I leave it with these three main questions. I would, of course, have also private law issues which could be discussed, for example, access to data, who does have access, who should be hindered of having access, as well as secondary use of data, or what about the development from data reporting to data sharing, or what about data quality? This is all from my side for the moment, and I would like now to open the discussion. I know that we are advanced in time, but I'm sure that a few interesting questions could be raised and should also be answered by our highly qualified experts of this afternoon.
Well, I will address your first question as far as our work about, do we have secondary review of algo techniques? You know, how do we know that they're properly functioning? And I should say that in our agency, we always send out everything, every major analysis we do, we send out technical descriptions of what we do to at least 3 reviewers and get their feedback on it and adjust accordingly. So yes, there is review in our case.
Okay, thank you very much. Further remarks, questions?
Well, I can jump on that. This is the same for us. The algorithm that we use, they are reviewed because I think this is a good practice. You need to have it. So if not, you are just working with a data set, but you are not working with sound evidence. But maybe from the lots of questions you mentioned, all are good. But one, from my perspective, you mentioned the potential diminution of supervisory judgment, and I think it's the contrary. It's increasing. You need better supervisory know-how and judgment because you have more data, you have more evidences, and you have to have the people able to screen these evidences and also to program this. So you cannot say to a data scientist, please develop a good algorithm for these special or specific prudential problem. You need the expert on these liquidity problematic, for example, to work with the data scientist. So I think supervisory judgment is not changing with the data-based evolution. It's the contrary. You will need more of it just to screen the right way to work this data.
Okay, thank you very much. There is a question in the chat, and this question is addressed to all, but possibly it could be particularly answered by Mr. Huber. Is there a future beyond bid ranking for algo analysis?
Sorry, I did not properly understand it. Is there a future for?
Is there a future beyond bid rigging for algo analysis?
Ah, yeah, absolutely. Now I read it in the chat myself. Yeah, I do think so, because what you could also do is actually you could consider markets the same way like you consider tenders when you use algorithms. Of course, again, the distribution of prices in a market will be different than the distribution of bids in a tender. But also there, one could learn the specificities of a specific market under collusion and under competition. And there's actually already a paper on this where I think it's for Brazil, if I'm not mistaken, where there were locally formed cartels of gas stations. So for example, in local markets, in cities or regions, gas stations formed cartels. And so the authors there used the same kind of procedures actually to learn from historical data. What does a cartel in the market of gas stations look like versus what does competition look like? And so if you just have data which are collected, for example, regionally at a specific point in time for a market or for several markets, then the rows which I showed you in my data set before, right, where you had the prices for the different tenders, you can just then have the prices here for different markets and use these methods there as well.
Okay, thank you very much. Betty, would you like to respond for the US perspective, or Chris for the UK perspective?
I think Chris may have a lot more to say about this than I do, so I'm going to let him go first.
Okay. Thank you.
Chris?
Yeah, I think you know, I think when we talk about algo analysis, you know, first of all, the use of algorithms extends by regulatory bodies far beyond sort of price data. Obviously, it's quite an important component, but there's lots and lots of activity that is going on, you know, on other forms of data. You know, for example, we've seen some really interesting work from, I think it came out of colleagues at Princeton who have sort of been doing sort of large-scale collection of advertisements that are on the web and the image content of the advertisements. And that is something that in turn, you know, there is a future world potentially in which that sort of data could be used by regulatory bodies to, you know, around issues around consumer protection. So there's definitely other forms of data which can be really valuable. And I think another thing about the way in which algorithms are now used in industry and in the private sector is that they do facilitate the sort of updating and maintenance of prices at a rate that previously was not possible, right? So, you know, at Amazon, for example, prices update potentially all the time. And I think it's important for, you know, I think once you've got that type of activity at that type of scale, it becomes very difficult for any form of manual review to ever happen to sort of validate the activity that's going on in those markets. If you had reason to suspect that there was some untoward pricing activity happening somewhere, you wouldn't be able to validate that across the entire catalog of products if there are millions. And so you necessarily would have to use some kind of anomaly detection algorithm in that realm. So I actually think, that the areas of bid rigging and cartel screening is, I think it lends itself very nicely to certain statistical and analytical techniques. But I actually think we're still at the forefront of working out how algorithms and technology can help protect consumers and promote competition.
Betsy, any addition?
Well,
or?
We've used it for other, we've used it to inform legislators on relative efficiency of different groups, and there's all kinds of algorithms you can use and all kinds of settings you can use them in. And you know, I don't know as much about the competition setting, but I do know that for other regulatory settings, we have been able to use machine learning to inform the situation, just without limit, practically.
Thank you very much. Sorry, Peter, I interrupted you 2 minutes ago. Now it's your turn.
Yeah, sorry, it was a bit like a devil's advocate question that also, you know, goes slightly to Manny Reinhardt's points. I mean, so it is fascinating, right? And I totally see that works for bid rigging and stuff like that, where we may have good data. But, you know, now we are headed towards ever more kind of proactive ex ante digital regulation and supervision activities by the authorities. Right now, I mean, you all know about the Digital Markets Act and Data Act and stuff like that. And there are, as far as I'm aware, also regulatory ideas in the US. And for that, you might use these tools as well. And the question really to me is, how can we ensure that we have appropriate data sets generating appropriate assumptions and appropriate procedural tools that prevent us, authorities and courts alike, and also practitioners, from, you know, falling into the traps of false, not only false negatives, but also false positives, right? So I found it very interesting to hear about or to think about during Alain Girard's presentation about whether additional reporting obligations, or maybe more structured reporting obligations by certain companies, could help to create data sets that help the competition authorities, not the financial market authorities, but competition authorities, to, you know, make more resilient and better, higher quality assumptions, also beyond the realm of bid rigging, where maybe the data set situation is a bit particular. And maybe as another thought, it might be helpful to have early on procedural tools to you know, address the assumptions or the models as such before they are used for a particular case, and then courts look into those years and years and years after the actual investigation took place, let alone the conduct being investigated. So this is not a very precise question, but I would like to hear, you know, maybe from all of you, whether you think that we need such procedural safeguards to operate the new tools for new fields in a proper way. Manny, would you support me on that, or do you think there is no need for such safeguard?
No, I think, first of all, I believe that if we do procedure properly, there are enough, you know, safeguards. So you can appeal a decision, and there has to be a full factual check, and the parties have to have access to all this data. And I think that the Seecaster case, to my knowledge, this is also at the Federal Administrative Court. So I think the essential thing is that parties who are affected by this, they have access to the file, they have access to the data, they can fully review the data. I mean, so far this was not a problem because all this bid rigging data was basically public data. So all the prices, they were basically known to all the participants. And as long as this is I mean, as long as this data is open to all parties and they can access it, they can argue before the court, I think it's not a problem. I think it starts to be a problem if these things get so sophisticated that the courts start trusting these algorithms more, you know, than our own human logic, and without properly assessing it. But I'm quite confident that our system can handle that.
Maybe if I can react, before you introduce new supervisory duties for non-regulated companies, because this is a big difference in antitrust or competition. You have non-regulated companies, most of them. We are just dealing with regulated companies where there is a concern. This is financial stability. So I suppose that it's a bit different than from protecting competition. But as an economist, I would say before you introduce new supervisory duties, you have to consider that these duties have some cost on the economy as well. So I'm not sure that this is the best way of increasing competition when you introduce a kind of general supervision mechanism. For example, in the banking area in Switzerland, very concretely, this is my second most preferred topic. This is about proportionality. So we really try to regulate and to supervise less the small players, so they have less regulatory reporting duties from now on. This is a small banking box, it's called like this in Switzerland. And this is exactly for that reason, because small companies, middle companies have a lot of costs for compliance task, and we think that it's better to reduce these costs so they can play in the market. And I mean, I would say, I don't know exactly how it is in competition area, but to introduce some supervisory reporting duties is not an easy task, and maybe politically a bit complicated as well.
Does anybody else would like to respond? Martin Hu, for example?
Yeah, just about procedures. I think one important thing is also data quality, right? And here, and the assumptions you mentioned before, because the assumption, of course, is that we correctly know in the historical data, for example, when a cartel was in place and when not, right? And of course, when we collect this historical data, maybe we don't always know this for sure, right? You mentioned about these things about false positives, false negatives, right? It could be that, for example, the example I showed before with the Ticino case, maybe there was some collusion going on before the cartel was formed among all cartel members, and maybe there was the later point in time, a period where even after the cartel, people started to collude again. So when we use the data, we usually take data where we know there was a court ruling, and from the court ruling, we know when the cartel started. And then the assumption is right after the cartel has been dissolved, there's no immediate new cartel. Mm-hmm. That's an assumption we need to make, right? So that's a crucial point, as you say, that the quality of the data. Yeah.
I see.
Well, thank you very much. Betty or Chris, do you have any amendment, any additional remark to the original question of Peter?
I think I agree a lot with Martin on the data quality issue. And I think another thing that we, particularly here, thinking more about enforcement and thinking more on sort of the consumer and the antitrust side, but markets regime as well. I mean, as a when you are in a position where you are requesting information from parties, rather than sort of having information be made available to you sort of in an open format, you need to put together, your data request through whatever legal mechanism you have to do that, and then you sort of send it away, and then your data comes back or doesn't come back in whatever fashion it might be. And I think one challenge of this approach, and one thing that we need to sort of constantly bear in mind, is that, first of all, obviously our requests have to be proportionate in terms of the amount of data that we're asking for, but sometimes we do find in the data analytics realm that you don't know with 100% certainty what data will answer what question, until you may actually sometimes see some data and realize that it doesn't necessarily answer the question that you had in mind. So I think we have to be conscious and very considerate of how we think about and shape our data requests in the best possible way. And I believe, I might be incorrect here and others may have more insight than I do, so this may not be right. But I remember hearing at some point that certain companies in the US at least had sort of opened up their sort of data warehouses in a way that would allow investigators to sort of come in and look directly at the data themselves in a secure and safe and regulated format. And I think that type of approach is quite interesting. And I think as we get into more ex-ante activity, we are going to have to think about how the data exchange between regulators and parties works in a way that doesn't cast an undue burden on either group.
Well, thank you very much. Betty, a final word?
Well, it's just the problem is historical data, because a lot of current data you can scrape from the web. Lots of current data, like in highway procurements, you can go to the different state websites in the US and get the data. But the problem is getting a historical series that will really allow you to use these machine learning and other methods. And for that, you do need to have the data. And in our case, the data, most of the data that we are using for our effort is each one is from a different state, and the states collect them in different ways. And there is no standardization, and that's a real issue. So, yeah.
Okay. Well, usually Swiss people are known for being relatively precise, if not to say very precise. We already exceeded our time by more than 10 minutes. Therefore, I would propose that we are coming to a close. I would like to thank all speakers for their most interesting presentations. Personally, I learned a lot, and I'm sure that we have not yet finally discussed all aspects. In other words, the discussion is certainly going on. Therefore, really a big thank you also on behalf of Peter Picht and Zipko and Ascola. Thank you also to the team of Peter for the technical organization of this online conference of this afternoon. I would like to wish you all a nice evening, at least for Swiss people, or a nice afternoon in the United States. Thank you again, and hope to see you either physically or in another online event soon. So thank you and goodbye.
Thank
Thanks
you.
so much. Bye-bye.